Good morning, ladies and gentlemen, and welcome to our conversation starter, where we'll be discussing why estate planning doesn't have to be complex. My name is Tracy Muller. I'm Head of Fiduciary Advice at Nedbank Wealth Management, and I'm extremely delighted to be joined by my team members today, the Fiduciary Advisory Team for Nedbank Private Wealth and Nedbank Financial Planning, and we're going to be joined by them in a little while. In fact, we're going to be joined by Ilana Oosthuizen and Priscilla Reddy, who are based in our Johannesburg, Central and KZN region. We're also going to be joined by Haneli Lagrange and David Jordan. They are fiduciary specialists in our coastal region. And we're going to be joined by William Kwela, who is a senior tax specialist. But really, the purpose of these conversation starter sessions is to be able to engage with you in an informal virtual environment where we can hold richer conversations following the main thought leadership webinar. And in particular, we're referring to the one we hold on the 1st of September, when we shared with you how you can avoid financial disasters for your loved ones, including hearing the real life story shared by Nikki Bush, who spoke about what if happens. So whilst we cannot control when a what if moment happens, what we can control is how we choose to plan and be prepared for these what if moments. So, to get the thought process going, the fiduciary team are going to be sharing some estate planning tips with you today. But before we get there, and while we're connecting with you online in this way, it is important to reflect on connections and connectivity in general, but especially when it comes to our money and financial matters, because your money decisions connect your goals and needs, your dreams and fears, your attitudes, and the role you play in your community to how you earn, save, and spend. And in essence, that's what we refer to as connected wealth. It's the fact that every single financial decision you make is informed by and affects every aspect of your life, including your ability to protect what is important to you and to achieve your life goals and aspirations. And that's why at Nedbank Private Wealth and Nedbank Financial Planning, we utilize our globally integrated advice-led approach to enable you to connect your financial decisions to your life goals and aspirations. And practically, it means providing our clients with access to technical expertise, such as the expertise we're going to be showcasing today, appropriate opportunities, access to global solutions and services across Nedbank and other top providers. But most importantly, it's about connecting you to personal and objective advice to enable you to make better life decisions and avoid financial disasters. So before we get into the actual discussion today, just a few housekeeping matters. Firstly, just in terms of the format of today's session, I'm going to shortly hand over to a couple of our team members, and they've prepared a slide deck really just to try and get the thought process going and to position why estate planning doesn't have to be complex. They're also going to be sharing some tips with us in terms of estate planning, some really useful estate planning tips. This will be followed by a Q&A session, and we really want to hear from you. So please make use of the Q&A chat box, post your questions to us, and those we're going to address to the broader team that are going to join us during that Q&A session. You will receive a link to this recording after this session, so you'll be able to watch it again or share it with your friends and family. If your screen should freeze, don't panic. Just press the F5 button and it should take you back to where you ended. So, without any further ado, I'm going to start handing over to the team. They're going to take us through some slides that they've prepared, and they're going to position why estate planning doesn't have to be complex. So over to you, Haneli.
Thank you so much, Tracy, and welcome to everyone on the line. So, as fiduciary specialists, we understand that estate planning can appear quite daunting, and it's likely because of its perceived complexity. So, as a result of this, estate planning is often neglected or continuously postponed. The important thing to bear in mind is that the foundation of any sound estate plan is ensuring your financial goals and aspirations are achieved. Keeping in mind, however, that these goals and aspirations can change throughout your life journey. So, for example, when entering into a marriage or welcoming a child into the world, or even other life events which are outside of your control, such as becoming incapacitated or passing away. So, during this presentation today, we'll be sharing a few practical tips to help you ensure your estate is structured optimally for all life events. So, first, we'll get back to the basics of estate planning. Then we'll hear from our fiduciary specialist on some useful tips in respect of certain aspects. And then we'll be addressing, like Tracy mentioned, we'll be addressing your questions in our panel discussion. But first, let's get back to the basics. So to ensure one's wealth is structured optimally, we generally consider the fundamental factors set out on this slide. But these factors can be best illustrated by asking yourself a few fundamental questions. So, what are your financial goals and aspirations? Not only for yourself and your family, but also for your family, and not only during your lifetime, but also thereafter. Does your current wealth structure ensure cost efficiency and allow for changes over time? How are these goals and aspirations affected should you become incapacitated, face sequestration, or even pass away? Do you have minor children or other dependents that will be financially impacted by these life events? And important as well, do you have a valid, up-to-date, and executable will? Understandably, not everyone's answers to these questions will be the same, as there is no one size fits all in estate planning. Instead, each person should consider his or her estate planning in light of their own personal circumstances and needs. Having said this, however, our fiduciary specialists have come across some recurring themes or pitfalls in their extensive experience. Let's now hear from them on some of their top tips to ensure that at least the fundamentals are in place. Although, do please keep in mind that this is not an exhaustive list. Okay, over to you then, David.
Thank you very much, Haneli, and good morning, everyone. Today, the first aspect that I would like to cover is how does one plan for access to your finances when you become incapacitated? Now, generally, diseases like Alzheimer's or dementia, which are often associated with old age, can sometimes impair a person's ability to such an extent that he or she is not able to or competent to manage their affairs. Now, in South Africa, we do not have the concept of an enduring power of attorney. So it's a common mistake that people believe that a power of attorney, if they appoint a family member, that that family member can act on their behalf if they become mentally incapacitated. The issue here is that for a power of attorney to remain valid, the person who issues the power of attorney must always be able to mentally or have the contractual capacity to revoke the power of attorney. So if you do become mentally incapacitated to such an extent that you cannot revoke the power of attorney, that power of attorney is not valid anymore. So the only alternatives then would be possibly then to appoint a curator. A curator bonus, it's a process that you need to go via court. It's a costly process and it's often a lengthy process so that the court appoints a person that can act on your behalf. I think the other important point there to remember also is the will. And that's one of the reasons why one would need to update your will regularly because, once you become mentally incapacitated, you cannot change your will anymore. So that will remains your last, valid will. So what is the practical tip and the best alternative to this? And in this case, it would be what we call a discretionary trust. So if a person has a trust and he's let's say one of the trustees, and he becomes incapacitated, it's a fairly easy process to replace that person with somebody else to act as a trustee on that trust. And moreover, when a person is a beneficiary of a trust, say a discretionary beneficiary of a trust, and that beneficiary becomes incapacitated, the trust is there to look after that beneficiary quite effectively, and the trustees would effectively make those decisions. So in this case, a trust definitely gets the mark. If I go to the next slide, and the next aspect that I would like to talk about is how do you ensure that you protect your assets if you become insolvent? And generally, when a person becomes insolvent, the creditors would lay claim to all the assets in that person's estate. But there are one or two exceptions, and I would like to focus on those. So the first one is an endowment policy. So the benefits of an endowment policy will be protected if you meet certain requirements. And these requirements are that you or your spouse are the life insured under the policy, and the policy has been enforced for at least 3 years. So typically, when one doesn't necessarily plan for, insolvency, but it is always good to have these options available. And so endowment is one. If you look at a company affords, protected benefits. If you look from a company's perspective, if the company is liquidated, generally the creditors would not be able to lay claim against the shareholders' estates, because unless, of course, the shareholder has to surety for the company's debt, and vice versa. If a creditor, if a shareholder becomes insolvent, typically the creditors would not be able to lay claim against the company assets. So there's some protection there. But yet again, as we've seen with incapacity, the discretionary trust does hit the mark. So there, I would like to distinguish between two aspects. One, typically you would have when you have a settlor or founder of a trust, the trust would typically be funded by that person by means of a loan account. And generally then the trust would invest the assets in, presumably, hopefully in growth assets. And then over time, the growth takes place in the trust. But the loan account remains an asset in the hands of the funder. Now, to the extent that if the funder becomes insolvent, his estate, they would be able to lay claim against the loan account, but certainly not the growth in the assets that are held in the trust. Also, then, if we look at the trust from the beneficiary's perspective, typically with a discretionary trust, the beneficiaries have no right to claim anything from the trust. So at best, they have a contingent right, and that effectively means they have a hope to receive a benefit in future. So if a beneficiary becomes insolvent, the creditors will not be able to claim assets that are held in the trust, as the beneficiary has no real rights to claim against the trusts, hence the protection. So these are two tips that I'd like to share with you, but now I'd like to hand over to Elana.
Thank you, David. Good morning, ladies and gentlemen. Today I'm going to highlight some important tips when drafting or reviewing your will that can assist you to avoid the pitfalls of a poorly structured will. However, it's important to remember that each person's circumstances are different and no estate is identical. So let's jump straight into it. So tip one, I think, is probably the most important tip of all, and it's something that Hanneli has also mentioned, and that is having a valid, up-to-date will. I'm not going to cover the legalities of a valid will due to time constraints this morning, but if you are unsure about the requirements of a valid will, I suggest you talk to your financial advisor or your wealth manager about this. Having a valid, up-to-date will give you peace of mind that your wealth will be distributed the way that you intended. We often meet clients that drafted their wills 20 years ago when they first, for instance, got married, and they did not update it since then. It is important that you review and update your will quite regularly, and we normally suggest that the client review their will when there is a change in circumstances, for instance, the birth of a child, divorce, or for instance, if there is a change in your financial circumstances, as an example, the acquisition of a new asset. I'd like to point out as well that many clients are also moving funds abroad and acquiring assets outside of South Africa. In this instance, it's important that you review your will to make sure that your will deals with this particular asset. Let's move on to tip 2. It's important that you review the revocation clause in your will. This is specifically applicable to clients that have separate wills in different jurisdictions and dealing with those specific assets in that jurisdiction. In short, the revocation clause revokes all of the wills and codicils that you, the testator, have made in the past. And the purpose of this revocation clause is to prevent any of your earlier wills and codicils from having any legal effect after your new will is executed. So it's very important that you check that separate wills in different jurisdictions do not accidentally revoke one another. Okay, let's move on to another tip. It's important to check the validity of any will executed during lockdown and to make sure that your will fulfill the necessary requirements. If your will was not executed properly, your beneficiaries will have to approach the High Court for condemnation of your will, which can end up being a lengthy and a costly process. Many clients executed wills during lockdown and due to circumstances at the time did not follow the requirements laid down in the Wills Act. As an example, some people signed their wills electronically. Please note that an electronic signature are not acceptable. A wet ink signature is required. Also ensure that original signed wills are kept in safe custody with your executor or that they are kept in a safe place. Also ensure that that the witnesses that signed on your will were competent to actually sign. Okay. Tip 4, I would say, is to draft separate wills for spouses. What do I mean by this? Any 2 or more persons can execute a joint will. Joint wills are commonly executed by spouses, but they are not confined to spouses. A joint will is treated as 2 separate wills and is interpreted as such, and the bequests of each person are treated as bequests from their own respective estates. Having 2 separate wills instead of a joint will is recommended as it's easier to deal with from a practical and an administrative perspective. On death of, and what I mean by this is, on death of the first dying, the original joint will has to be lodged with the Master of the High Court, and the surviving spouse will then either have to get the original will back from the Master's office after the finalization of the first dying spouse's estate, or alternatively, they would have to draft a new will, and this could prove to be a challenge. Note also, Netgroup Trust only drafts single wills. Okay, tip 5 is to amend your will on divorce. It is a common occurrence that a person makes a bequest to a spouse in their will, and what happens to this bequest in case of divorce. The Will Act provides that if a person dies within 3 months after divorce and that person executed a valid will before date of divorce, that will shall be implemented as if the former spouse had died before date of divorce. In summary, then, you have a window period of 3 months after your divorce in which to change your will. If you die during this period, any provision that benefits your former spouse will fall away. It is therefore important that you amend your will when you start the divorce proceedings, and importantly, you also remove a former spouse on any beneficiary nominations on retirement funds and life policies. Okay, tip 6. Deal with trust loans and withheld distributions in your will. Remember, amounts owed to you by your inter vivos trust, for instance, loans and withheld distributions, are considered assets in your estate and should be dealt with in your will. Loans to trusts, you should consider bequeathing any outstanding loan amount owed to you by a trust in your will. If you bequeath the loan account to the trust, which owes you the amount, the debt is effectively cancelled and does not have to be paid back to your estate by the trust. Otherwise, it's likely that the executor could call for such payment from the trust. The reduction or cancellation of this outstanding loan account should not trigger capital gains tax as a debt forgiveness, however, provided that certain conditions of the 8th schedule are met. Tip 7, keep in mind that some assets are dealt with outside of your will. Beneficiary nominations on life policies or retirement funds ordinarily take precedence over wills and are dealt with outside of your estate. Therefore, it's very important to check beneficiary nominations in order to make sure they are still in line with your wishes. Retirement funds, for instance, are governed by the Pension Fund Act and specific fund rules. Retirement funds are managed by a board of trustees responsible for the allocation, distribution, and payment of lump sum benefits payable on a member's death in terms of Section 37C of the Pension Fund Act to the member's dependents. And death benefits are expressly excluded from a member's estate, and the benefit will be dealt with in accordance with Section 37C of the Pension Fund Act. Looking at life policies, you can nominate a beneficiary on your life policy. On your death, the proceeds of the policy are then paid to the beneficiaries as nominated on the nomination form provided by the company that issued the life policy. The will cannot deal with distributions of that policy proceeds unless the policy proceeds are paid to the estate. Now, when does the policy proceeds will be paid to the estate? Well, for instance, the policyholder, if the policyholder nominated his estate as the beneficiary on the nomination form, or when no beneficiaries have been nominated and there are no dependents, or if the nominated beneficiary dies before the life insured dies. If this is your intention that the proceeds payable to your estate should be used for a particular purpose or devolve on a specific person, your will have to stipulate this. That is very important. Okay. Tip 8, enforceable conditions versus ruling from the grave. Make sure that the conditions in your will are permissible, enforceable, and practical. And try to avoid as far as possible try to rule from the grave by imposing certain conditions. Note that in instances where a condition is not enforceable, the bequest to the heir will not be considered invalid. However, the heir will receive the inheritance through of that condition. And then lastly, appoint a professional executor. I get this question quite often where a client would ask me, should I appoint a family member or a professional executor? And my answer is definitely to appoint a professional executor. Appointing a professional executor ensures smooth administration process, reduces delays and stress on your loved ones. You can approach Nedgroup Trust to assist with the executive function. This will give you access to the advantages of having a professional corporate executor. And some of these advantages would include, for instance, continuity, which means that changes in the individuals who may deal with your estate do not affect the executor appointment. It also includes ease of administration, as the corporate executor has the required systems and processes in place to deal effectively with the administration of estates. And corporate executors stay up to date with legislative and other changes, which means the client can be rest assured that his will is structured according to the latest regulations, and then provide peace of mind. Dealing with a large corporate means you have the security of an executor that is established and accountable. Thank you. This concludes my tips on structuring of your last will and testament. I now hand back to Hannelie.
Thank you so much, Ilana. Over now to our tips on the so-called cost of dying. So essentially, this refers to the costs that will need to be covered after your death, which could include immediate costs such as the cost of the funeral, outstanding debt and liabilities like a home loan or a credit card, estate administration fees, for example, executors' fees, and then, of course, taxes, including your estate duty and capital gains tax. So a major concern here is that your estate could have a liquidity shortfall. In other words, there could be insufficient cash and assets easily converted to cash to cover the mentioned costs. So if this is indeed the case, it could not only put your loved ones at financial risk after death, but also potentially derail your estate planning done during your lifetime. Our first step here is to minimize or reduce the financial impact of your death, or so-called cost of dying. So let's look at a few ways you can achieve this. So first, you could reconsider who you nominate as the beneficiaries of your life policies. So as Ilana just mentioned, the important point here is that if your estate benefits, the executor's fees would apply to the proceeds, since it will flow into your estate and devolve as per your will. So you could therefore instead nominate an heir directly to reduce the executor's fees. Further, if you nominate your spouse as the beneficiary, the spousal rollover would apply, meaning that then it's then also deductible for estate duty purposes, the value of those life policy proceeds. You could also consider making bequests of personally held assets to your spouse in your will, and this would again result in that estate duty rollover applying, but also capital gains tax rollover, so a rollover of base costs, if that is a capital asset bequeathed to your spouse. Another way of minimizing estate duty and capital gains tax could be to bequeath assets to charities, so assuming you do have a philanthropic intent. A further one that's often overlooked is to retain accurate records of any improvements made to capital assets, such as your immovable properties. So this is really essential to substantiate an increased base cost and thereby reduce your capital gains tax liability at death. Lastly, you should also avoid making contributions to retirement funds above the annual tax deduction limits, since these so-called disallowed contributions are included in your estate for estate duty purposes at death. But please do note here that this is very much case specific, as there may be instances where it could actually be beneficial during your lifetime to have those disallowed contributions from an income tax perspective. Okay, so a further tip is to consider pegging the value of your estate for estate duty and capital gains tax purposes. And this can be done through transferring growth assets, so in essence, capital assets, into a trust set up and funded during your lifetime, either by way of donation or loan. So the value of these assets would then in effect be pegged at the value at date of transfer, since it will going forward be assets outside of your trust and effectively outside of your estate and effectively in your trust. Important, however, as they say, the tax tail should not wag the dog. So there should be other traditional benefits of making use of the trust that should apply in your personal circumstances. And it's essential, however, here to speak to a specialist on this option, as there are other cost implications to consider, which should then be weighed up against the traditional benefits and the benefit of pegging the value for estate duty and CGT. Another tip is to ensure that the costs in your estate are provided for, to avoid a scenario where, for example, a bequest of immovable property in your will is no longer enforceable, since your executor would be forced to actually sell that asset to settle your estate expenses. Important to keep in mind here is that this could even be an issue where you have your spouse as the sole heir, albeit to a lesser extent. A few ways in which we can ensure that costs in your estate can be settled after your death include taking out a policy to cover funeral costs. Although this may seem immaterial, the cost of a funeral can be much more than expected, especially where the deceased had special wishes. You can also consider taking out credit life on all your outstanding debts and liabilities, and or a whole life insurance policy payable to your residual heir. Lastly, you can make regular contributions to your cash reserves to grow these or increase your assets that are easily converted to cash. And these include interest in unit trusts or shares. Let's now look at our tips on the estate administration process. And please keep in mind here that this is generally a long and tedious process with many potential outside factors that can cause delays, including the turnaround times at the master's office. At best, we see in the current environment, these estates taking about 12 months minimum to finalize. And the process can really take even longer than that, where the deceased affairs are more complex or information is difficult to obtain. In order to streamline the process, you can, during your lifetime, help your loved ones understand what to expect and what they need to do should you pass away. And an important first step here is for your loved one to report the death to a Home Affairs official as soon as possible in order to obtain that death certificate. So in many cases, a medical practitioner or hospital would actually assist you in this regard in order to obtain that death certificate. This is the very first step in the entire process. With regards to access to money, it's also important for your loved ones to understand that your bank and investment accounts will be frozen as soon as your death is reported. This means that they will not be able to access these accounts until at least the executor is appointed, which is generally taking about 8 weeks currently. This is why it's so important for you to also make provision for your dependents' immediate expenses by having cash reserves in separate emergency accounts in their names. Your loved ones should further understand that they need to initiate the estate administration process as soon as possible by contacting your wealth advisor or even fiduciary specialists, who will then be able to assist with identifying where the will is held so that the executor named in that will can report the estate to the master. And please keep in mind here, we've received the question before on who can view the will at that point in time. Keep in mind, it's only the executor and the heirs named in the will that are allowed to view the will. It's not a public document. Okay. So having your so-called life file in place or a what-if file, as we heard from Nikki Bush and which Tracy mentioned a bit earlier, that can also speed up the initial information gathering phase in the entire process. And this can really be done by recording and collating information and documents that are critical to managing your affairs and that can be requested as part of the estate administration process. So these we've listed on this slide that we won't go into detail today. This information and documents, or at least a safe location thereof, should then be shared with your loved ones for easy access after your death. To summarize then, estate planning doesn't have to be complex. Your focus should be on getting the basics right, which are your building blocks to structuring your estate optimally for both during and after your lifetime. And by doing this, you're giving yourself the gift of peace of mind. As mentioned, however, there is no one size fits all. It's therefore essential to obtain specialist advice to connect your financial decisions to your life goals and aspirations. Please do reach out to your regional fiduciary specialist or wealth advisor so that we can help you connect those dots. Thank you so much. And Tracy, back to you.
Great. Thanks, Hanali, David and Ilana. Sure, a lot of tips and food for thought. And I can see it's also got our audience kind of thinking through things as well, because we've got some great questions coming through. But please, just to remind everybody to please make use of the chat function. And we're going to get into those questions in 2 minutes. Just very quickly, I think just a couple of things that really stood out for me. I think the first one is that, you know, those what if events, there is one certain what what if event that will happen, and that's death. But because estate planning is a living thing, we've also got to plan for those other what if events like incapacity, etc., as David took us through. But it doesn't have to be complex. As long as Haneli just said, now we get those building blocks in place, it really doesn't have to be complex. I think, Ilana mentioning those tips around the wills, I think is really, really great, because a lot of those things we often know, but we forget about. So it's really important to have that reminder. So thank you. I think the other thing that stood out for me, though, was as comfortable as it is important that we do talk to our loved ones about death. And we know it's not a happy subject, but it is important to speak to them about it so that they can be prepared and know what to expect when that inevitable happens. But I think you were spot on in the end there. There is no one size fits all. That also talks to the importance of getting personal advice that talks to your specific circumstances. Okie dokie. So looking at the chat function, and as I say, please continue to post those questions, and really great to see the questions coming through. I think the first question, and William, I'm going to pose this question to you. It relates to citus taxes. And the question is, if you own an exchange-traded fund domiciled in Ireland through an American broker, would this asset attract citus tax?
Thanks, Tracy, and good morning, everyone. The citus tax is really a tax that the country where the asset is located charges. It could be withholding tax or any other form of tax that they charge. But some countries choose not to charge those taxes. So Ireland generally choose not to charge citus taxes or taxes on the ETFs. So, but you will have to look into each country. Would depend on each country. So the likelihood is that in those cases, Ireland shouldn't be charging citus tax, but out of their own choice. But should you be invested in a country where citus tax is charged, you must also remember that you can have recourse to your South African DTA with that country to reduce the impact of those withholding taxes or any citus tax by giving you credit as well. So that is just one thing to just keep at the back of your mind about the citus taxes, that there's two countries involved, and being that country where the asset is located, but as well as South Africa. I don't know if any of my colleagues would like to add as well.
Yeah, no, I think that's great, William. I mean, I think the bottom line when it comes to the ETF is that it's actually the place where the issuer. It's got nothing to do with where the issuer, the entity, is registered, but it's more around. Let me rephrase it. It is about where the entity is registered. It's not about the exchange upon which the ETF is traded. I think that's the bottom line. I mean, that's the only comment I would add into that. But thanks, William. I think just turning, there's quite a few questions coming through on wills. So I'm just going to see how I can try and group some of those together. And I think, Ilana, I'm going to ask you to perhaps address some of these. The first question is, can a beneficiary of the will be a witness?
Okay, thanks, Tracy. So no, a beneficiary should not sign as a witness on your will. They would actually be seen then as predeceased. So make sure that no witness, actually, in fact, no person mentioned in your will should sign as a witness. That includes a guardian, a nominated trustee, executor, etc. And in a lot of instances as well, you need to make sure as well that where you, for instance, have a kid that is married, that kid or child's spouse also not sign as a witness. So my recommendation would be get someone totally independent to witness your will.
Yeah, great. Thanks, Ilana. Priscilla, I think I'm going to ask this question to you. and it's around executors' fees, which in a way is linked to the will. But how much do we need to pay for an executor?
Thank you, Tracy. So the standard executors fees is regulated. It's 3.5%, excluding VAT on the gross value of your estate.
Okay. Perfect. And obviously, depending on the size of the estate, the complexity of estate, generally, I think a lot of professional executors are open to negotiate on that fee as well. So just another question coming through. It's also relating to executors. So maybe we can just stay with you if you don't mind, Priscilla. But if a family member is appointed as an executor, do you still need to have a professional lawyer to submit documents to the master?
It's an interesting one. So Ilana actually mentioned it in her slides, the importance of a professional executor. So if you have a family member that has been appointed as an executor and they do not have the ability to administer the estate, they can appoint a professional executor to attend to the administration of that estate. So it's dependent on the individual per se, and then the corporate would then attend to the ease of administration as opposed to the family member if they do not have the expertise in terms of the actual administration of the estate.
Okay.
If
Great.
you don't mind, Trace, I just want
mm.
to add something there
Sure.
to Priscilla's comment. I think you need to bear in mind that you can appoint an executor in your will. It's still subject to the appointment of the master of the High Court, basically that person that you nominated in your will. And the master won't necessarily appoint someone, if they don't have the skills to actually administer the estate. So when you lodge those documents to get appointment, the master would, want to understand what your qualifications, etc., are, and they would then, ask you to actually appoint someone as an agent that would be able to assist you with the physical administration of the estate.
Yeah. And I think that's so important, Ilana, because of the fact that to administer an estate is not an easy process. And so to be able to do that, you effectively need to know what you need to do. And there's timelines, all sorts of things that have to be followed. So if one is going to appoint a family member, as you say, it's up to the master to ultimately decide. But it is important then for that family member to be aware that they can appoint an agent, someone that has experience and skill in actually following that administration process. Okay, great. So David, and really great to see all these questions coming through. My goodness me, I'm trying to keep on top of all of them. But there is another question. So David, I'm going to pose this question to you, and it's really to deal with pensions and life policy. But can you nominate a trust as a beneficiary to your pension and to a life policy?
Tracy, yes. In general, you can nominate a trust as a beneficiary of a life policy. And equally, in terms of the pension, there are specific rules that determine who the beneficiaries of a pension can be in terms of Section 37C of the Pension Funds Act. So it must be clear that the person who is to receive the benefit can receive that benefit via trust. So the trust would require some certainty or a vesting right in the trust, so that the pension fund is comfortable that the intended beneficiary will receive the benefit. So it is possible.
Okay, great, David. Sure, as I say, lots of questions coming through, but please keep them coming. Just another question, and I guess this question pertains to, often it makes sense to not only use one estate planning tool, but to use a couple. So the question, and I think I'm going to ask this question to Hanali if you don't mind, can you have a combination of a will and a trust to make it easier for one's kids if you are the only surviving parent?
Yes, definitely. So you're not limited to one estate planning tool. You can make use of a combination of them. And definitely where you've got children, If they're still minors, especially, you can make use of a trust, and you can consider what type of trust then would you like to use. Would you actually like to, in your will, provide for a testamentary trust to be established after your death? And then to fund that via your will for the benefit of your children? Or would you actually like to set up a separate trust during your lifetime, an inter vivos trust, and fund that during your lifetime to make sure that the funds are immediately available for your benefit of your children after your death? Just keep in mind that with having the testamentary trust, there could be delays because you still have to go through the estate administration process. You have to establish the testamentary trust, the executors and the trustees named in the will. Whereas if you do that during your lifetime, that vehicle is already in place. And it's basically just for the trustees to then take over the role of covering the living expenses for your children and whatever other needs they may have. Yes.
Yeah. Great. Thanks, Hannelie. So another question, and William, I think I'm going to ask you to answer this one, please. It relates to endowments and tax-free saving. Are they in or out for estate duty calculations?
Hi, sorry, I was trying to unmute there.
Not a problem.
Yes. When you look at the tax-free savings, they're just an asset in your estate as well. So you know that will be in your estate as far as I can see. And then endowments is also an asset in your estate. So it's part of your estate as well. Yeah,
Okay.
that's my take on it.
Absolutely. So they're both included in your estate for the
Yes,
purposes of estate duty.
that's
Okay,
right.
great. Thank you, William. So another question, and this relates to executorship. So I think, Priscilla, let's maybe bring you in here again. What happens if the executor dies within a few days of my death? There's actually two questions here. Must an heir have a copy of the will? So I think those are two interesting questions, and I think two very relevant questions.
Great, Tracy.
Yeah.
So I'm going to answer the first one. If the executor passes on within a short period and you do not have an alternative executor, then the master would need to appoint an executor. So you have a risk there of not having an alternative executor. That's why it's important to appoint a corporate or professional executor, because that ensures continuity. Whereas if you have a individual, then you're not afforded the continuity, and then you're reliant on the master for the appointment of an executor, and it's not somebody who you would have necessarily wanted to actually administer your estate. Going on to the second question, Tracy, sorry, if you wouldn't mind just addressing that again. A copy of the will. Was it
yes. So must an heir have a copy of the will?
So it, again, the original will needs to be with the executor. If the original will is not available, then yes, a copy should be with, well, not necessarily an heir per se, because it depends on the client, if they're comfortable. So it depends on a case-by-case scenario, if the individual would like to share a copy with an heir. So it's, it depends, because it's a very private document, and it depends if you want to share that document. I wouldn't say actually having a copy, but perhaps knowing where the copy is. So, for example, with Nedbank, if your will is in safe custody with us, then you would share it with a possible heir to say that contact Nedbank, they have the original will, or my copy is kept in my safe. So not necessarily for an heir to have a copy, because it's dependent on the client.
Yeah, absolutely. And I guess that talks to the point that I think Hannelie touched on in the presentation around the fact that it is important to make sure that your heirs and beneficiaries, that your family, your loved ones, that they know where those important documents are. And if you do have a professional executor appointed, that they know who that is, and they know who your financial advisor is. Things that we often take for granted, because we deal with those people whilst we're alive, but when we're no longer here, does somebody else know who was actually we were dealing with to get advice, etc.? So it is important to make sure that your loved ones do know who your financial advisor is, that they know who the executor of your will is, etc. Okay, so William, I mean, another question for you. It's around taxes, but it's from an estate duty perspective. What amount, if you have assets, do you start paying taxes for at death? So it's really talking to what is the primary abatement, and what is the percentage of estate duty effectively that one would pay here in South Africa?
Tracy, the primary abatement currently the 3.5 million. And then the state obviously has to pay the duty 20%, I think. Yeah. So, yeah.
Yeah, so it's 20% on estates up to 30 million, and then 25% on estates above 30 million.
Yes,
yeah,
that's
yeah,
right. Yes, it's
yeah,
graded.
Yeah, absolutely. Okay, great. Thanks, William. Just having a look. What is the minimum amount of the estate that will require an executor? And I think that's quite a good question. Ilana, can I ask you to maybe just address that?
Yes, sure, Tracy.
Mm.
So there's two processes, basically, if I can call it that. So if your estate is below 250,000, it is a different process. To an easier process to administer your estate. If you have an estate above 250,000, that is where you need the letter of executorship. That is a process also that will have to be followed in terms of, placing advertisements in the government gazette and local newspapers. So there is a difference, and the difference comes in at I would say 250,000.
Great. Thanks, Ilana. And another question, I mean, we do see a lot of our clients are, they are diversifying their wealth, they are investing internationally. So this is really a great question in that regard. And I think I'm going to ask Kanali, if you don't mind, what is the best way to keep offshore assets offshore after death?
Well, that's a good question, Tracy. And in the end, your offshore assets can remain offshore if they are authorized. In other words, if you used your foreign investment allowance to obtain those offshore assets, if you inherited it from abroad, if it was donated to you, etc. So if it's authorized, the general rule is you can keep that can be kept abroad after death. So previously there was a disclosure that was required through your authorized dealer, but that has now also fell away. So, but the only two things really, where those offshore assets could be repatriated back to South Africa, two things that come to mind. And the one is that we focused on now on the slides is in terms of a liquidity shortfall. So if you have a worldwide estate, you are subject to estate duty and capital gains tax here in South Africa on your death. You have other estate expenses. Your cost of dying then exceeds what you have in South Africa in terms of cash and assets easily converted to cash. Then your executor needs to look elsewhere. So where would they look otherwise? Instead of your fixed assets in South Africa, they'll look offshore in terms of your safe investment portfolios, your unit trusts, shares that are those assets that are easily converted to cash, or if there's even cash abroad. So in that instance, we have the risk that your offshore assets now need to be realized and come back to South Africa to actually settle those expenses, estate expenses. The other thing that comes to mind is where you have a will that provides for the testamentary trust that we mentioned a bit earlier, that testamentary trust would be established in South Africa. So keep in mind that in terms of current exchange control rules, a South African trust is not allowed to hold or invest abroad. So those assets, if you actually leave those offshore assets to a South African trust, say that's for the benefit of your minor children, then in effect, those offshore assets would have to be realized and brought back to South Africa. And that's just in terms of current exchange control rules. We're hoping that to see a change in future, but at this point, that's still the case.
Yeah. Great. Thanks, Hanilee. And I see you've actually addressed two questions in that answer. We had another question here, which was on offshore assets invested via your annual foreign allowance in your personal name. Can they be bequeathed to a testamentary trust and remain in foreign currency, or do these assets need to revert back into ZAR? And you've answered that question, because currently, from an exchange control perspective, unfortunately, they would have to come back to SA. So, David, one of the other questions that has come up here, and, we always say that when one is in particular looking to invest, I think there's two important things. The one is to determine what is the right structure in which to invest your assets in or hold your assets in. And that really talks to the different types of legal ownership options that are out there and that are available. So the question is, instead of trusts, could one use a closed corporation or a company more efficiently?
Yes, Tracy. So, of course, each ownership option or structure that you choose has its own particular tax consequences, and the clients need to understand those. And for a corporate, you need to look at the corporate tax rates versus individual tax rates, and you also need to look at and you compare that typically to a trust structure. Now, a trust provides generally more benefits than a corporate, and sometimes people combine both trust and company structures. But a company or closed corporation is a very effective tool. It allows for multiple owners. It has its own particular benefits. So I think, if I understand your question correctly, Tracy, I think that is where it lies. So many people and many clients that I've come across do use a combination of company and trust structures. But typically for business purposes, closed corporation company both are much used because it's specifically geared for that.
Yeah. I mean, guess as you say, I mean, the important thing with the closed corporation or the company is ultimately someone's got to own those shares. And invariably, if you're going to own those shares in your individual capacity, you don't get the succession planning that you would have if, as an example, those shares were held through a trust. So thanks, David. So just frantically trying to go through the list of questions, trying to make sure that we've answered most of them. But I think just one more question, and Ilana, I think I'm going to ask you if you don't mind. Can Nedbank assist with a will covering assets in the US?
And Trace, so specifically with regards to the US, you can have one worldwide will dealing with, your assets worldwide. However, looking specifically at the US, we would normally recommend that you actually have a will in that jurisdiction. Remember, you would also have to appoint an executor in that specific jurisdiction. So if, for instance, you have a worldwide will where you've nominated Nedbank as the executor, Nedbank will have to appoint someone to assist them in the US to actually do the physical administration of that estate in the US. So it's very important, and it would depend on also the type of asset that you own in that jurisdiction that you get the correct advice. So in short, at the end of the day, Nedbank will not actually be able to administer that specific asset in that jurisdiction.
Yeah. Thanks, Ilana. And I guess that really talks to the point where, as you say, it's important to get advice on your particular circumstances. So just looking at the clock, unfortunately, I mean, as you can see, this is something we're passionate about. I mean, this is something that we do on a daily basis. Our role, in essence, is to try and ensure our clients avoid financial disasters. That's why we are here. And I could continue with this discussion all day. I could continue asking questions. I do think we've answered answered most of the questions in the chat. I do apologize if we haven't answered yours. We'll have a proper look at all of them afterwards. And if there were any we missed, we'll make sure that we do answer that question and that we do send you the answers afterwards. So really, thank you to the team, David, Ilana, Haneli, Priscilla, and William, for sharing your valuable insights with us today. I think just as a reminder to our audience, at Nedbank Private Wealth and Nedbank Financial Planning, we remain committed to providing you with globally integrated advice and connecting you to more ways to enable you to make better life decisions and avoid financial disasters. Planning your estate for whatever life may bring to you is one of the cornerstones of sound wealth and financial planning advice. So how can we help you? You've met our team of fiduciary specialists here this morning, and this team of fiduciary advisory team work very closely with our wealth advisors, with our wealth managers, our financial planners, our private bankers, our structured lenders. And we're really here to make sure that we help you achieve your life goals and aspirations. And we help you to be as prepared as you can for when a what if moment happens. So in closing, a recording of this session will be made available in the next few days. As I said right up front, you're welcome to look at it again, and we encourage you to share it with your friends and family. I think the more people we can help avoid financial disasters, the better it's going to be for us. So please do share that link when you get it. Please also remember that you can get more thought leadership insights, the recordings to previous webinars, and find out more about our future webinars on our Nedbank Private Wealth and Nedbank Financial Planning website. Your views matter to us, so please help us improve our webinars. And at the end of this webinar, there will be a QR code that will pop up on your screen. You can open your phone camera, you can snap it, and there's just a few quick questions that we ask you to just complete. If you want to take charge of your financial future and you haven't done so yet, there will also be details as to how you can get in contact with us so that we can make sure we can assist you with your estate planning needs. Thank you again to the Fiduciary Advisory team for connecting with us today and for sharing your valuable insights. But most importantly, thank you to each of you for joining us today. And we really look forward to joining with you again in the not too distant future. Until then, go well and stay safe. Thank you.